Welcome to the Agent Legal Lounge, the ultimate interactive weekly webinar that answers your burning real estate practice, contract, and legal questions. Hosted by distinguished attorney John George, co-chair of the Texas Real Estate Commission Broker Lawyer Committee, CEO and General Counsel of Special Provisions, and managing member of George PLLC. Tune in each week for an exciting, laid-back, and incredibly informative hour as John explores the Texas real estate profession, tackles hot topics requested by brokers and agents, and even takes your questions live. Get ready to dive in. The Agent Legal Lounge starts right now.
Good morning, everybody. I'm so excited you all could make it today. We're going to be discussing today the roadmap to compensation forms. There's, I don't think, any shortage of confusion on all these forms that are out there and all the changes that keep happening. And it's a very interesting time. So I really appreciate everybody being here today for that. And we'll go ahead and jump right in. It'd be helpful up front if you have available, pull up your 2401, your 2402, and your 2406. We're going to have a chart, our roadmap to the compensation forms today, but if you had those in front of you, it'd be very, very helpful. And so to introduce our co-host this week is Ed Zapata. He's a sales manager for Cooper Sotheby's International Realty in the Alma Heights and Stone Oak area around San Antonio. Ed and I have worked together for a number of years. I've represented Cooper Realty for, I think, 13 years now. Ed and I worked together 6 or 7, I think. Had a lot of adventures together. He's a longtime broker, the incoming Secretary Treasurer for the San Antonio Board of Realtors. And Ed, thank you for being here today. I would like to say a few words.
Yes, hello. Thank you for joining us today. Ed Zapata here, and I'm honored to be co-hosting the session with John George. Really looking forward to discussing agent compensation with all of you. And I'm confident that today's session will leave you with practical strategies you can implement right away. So John, let's get this started.
All right, we'll jump right in like we do every week. A few things up front. This is a public forum and we're discussing legal issues, but just know when your questions, and we'll try to take live questions coming up, not to disclose any confidential info. If you have any private broker forms or private client situations, let's make sure not to use names and anything that's confidential. Another thing too, this is providing general advice today. And so it's hopefully good general advice that's understandable, but it's not legal advice. So just make sure that you understand we're not providing actual legal advice today, but hopefully some good general information on all of these forms. So with that, we'll go ahead right to the roadmap. And many of you may have seen this online already. It's a roadmap that I prepared for trying to understand what all these forms mean in a one-page document. And I will tell you, this was not an easy task. And what we're going to do today is break this chart down and go through the actual forms as we go. And so hopefully you see it on your screen now. And I want to talk about this chart for a minute before we jump into it so you can understand how it works. So on the left-hand column side, these are the big ticket things that we have to worry about. And the one thing that is right on the front of our minds is how do we establish enforceable compensation agreements? And why is that important right now? All right, so under the new buyer's rep, I think it's drilled in all of our heads that we have to have a buyer's rep that sets the commission amount and it sets a cap. But how do we establish from there on whether it's only the buyer paying, whether the seller's paying part of it, or whether the listing broker's paying part of it? And so this chart's meant to summarize first on the top line of who's paying. So it sets forth the circumstance. And then if you go down that left-hand side, we're going to look at how do we establish it first with our buyer? And then we go to look at, well, how do we enforce it with the seller or the listing broker? And we're going to go to another slide where we break these down by columns, but just know that's what we're looking at here. And there's different concerns that are raised and different issues that come up with the use of these forms. So this is meant for a general option list. And I think with our conversations with our clients, we have some legal side and we have a practical side. And we're getting bogged down as we have to on the agent side. But our clients, you first have to do the job of gaining the trust, gaining that client relationship, and try not to worry about the forms too much up front. When it comes to explaining them to have them actually establish that agreement, it's real important to understand them on your side so you can explain it in an understandable way to the client. But if you lead in with that up front and try to explain this new contractual language that even us in the industry are confused about, it makes that conversation harder. So I wanted to lead in with that of we need to have this firm understanding, but don't let that drive right up front your conversation. Win that client first, win that trust, and then have this conversation with them. So if we look at this too, why is it important to now have a very firm understanding of these agreements? And why is it, how does it impact our clients in the transaction? Well, under the new buyer's rep, and I think, again, this is something we all have drilled into us, we have to have a buyer's rep in place before touring any home, right? In Texas, we know touring as showing. And it sets the amount that the buyer is having to pay their agent. In the agreements, they've always had this in there, but the buyer's rep, which is the first step on this chart, has an absolute obligation for the buyer to pay some amount. Or if it's no amount, we can't collect anything, we can't say our services are free. If we're going to collect any compensation on a deal, we have to have that buyer's rep in place. And of course, this is under the NAR rules and Texas Realtor forms that we're going over today. But so that sets the amount. And we have to be clear with our buyers to establish that up front before showing any home. Now, why that's really important too, both for us as agents and for the buyer, is that's the amount the buyer's coming out of pocket. It establishes the financial relationship in their bottom line. And as we're going into these deals, they're agreeing to pay that unless we can collect it from another party. And that may be a harder conversation than we're used to, but that's how it's structured. And that's how it always has been structured, at least in the recent past, as long as I can remember, in the Texas Realtor forms. We've always had the buyers, if you use that form, say, we're agreeing to pay X amount. And this historically, we haven't either held them to it or enforced the buyer's rep in certain cases. And we just look to the MLS offer of compensation to get what we could from the other side. That practice is now out the window. So that's setting the stage for what we're discussing today. And I want to jump in right with the first column. And we need to make sure this, like I say, one more point before I jump in. Our fiduciary duties to our clients, to put them first, to make sure they understand. As we go through these forms today in the 2401, 2, and 6, and have all those numbers spinning in your head, we have to get it right. Because if we don't, it impacts the buyer's bottom line. We are under those agreements, a buyer rep agreement, are agreeing to try to get it from somebody else. There's an affirmative obligation for us as brokers and the buyer's rep to try to secure payment from either the seller or the listing broker. So we're agreeing to make that effort. And today we'll discuss how you can establish a firm agreement. And if you don't establish a firm agreement, it absolutely can impact our buyer at the end because they're agreeing to come out of pocket that amount. Or they're going to look at you and say, you didn't establish it correctly, so I'm looking at you to pay it now, buyer's agent or buyer's broker. So take time to understand it and try not to get too worried about it. And we'll go through today to try to simplify those forms. So let's look at the first circumstance. And we'll take questions. If you have questions, put them in the chat. We'll try to take them as we go. And I really want to have this interactive to where you can ask questions at the end. I love this. Ed and I talk about these forums every day. Kirsten, who helped co-host last week, we've been talking almost daily on these issues. So looking at the first one, the buyer only. So if we're looking at only the buyer paying, the buyer's representation agreement is the only Texas Realtor form that we need to establish an enforceable agreement with that buyer. All right, that's about the easiest scenario out there. And it's important under the new NAR rules that to execute it before touring or showing a home. So if you had this chart, use this, make your own chart. establish these steps on when you need to do it and what you need to do. So buyer only, before touring a home, execute the buyer's rep. Now, practically for us as buyer's agents, that establishes what we're collecting, expecting the buyer to pay. And it sets a cap on the amount that we can recover from the buyer. Remember, gone are the old days that we can say, buyer, you're paying X, and I'm collecting whatever other amount I can get from other parties. We no longer can do that. It has to be clearly established in that buyer's rep, and it has to set an overall cap. Now, one thing we can do with all of these agreements is amend them, right? So if we have a particular deal, we're working for a long time, this buyer's asking us to do additional services that we may not have agreed to up front, we can always amend that agreement. But you need to make sure to do that if you expect to collect additional compensation. And so that's a pretty easy first step, buyer only, buyer's rep. So let's look at another only option. Another only payer option is the seller. And there's two different options that you can use with the Texas Realtor forms to establish the seller obligation to pay the buyer agent fees. We always, in every one of these examples, still need the buyer's rep, right? We can't collect anything from the other side if it's not in the buyer's rep. So that's going to be a common theme today. Have that established up front. But the two options for the seller only, which is the second and third column you see there, are either the 2401, which historically was a registration agreement between the owner and the broker. We use that with FSBOs, right? There wasn't a listing broker that used MLS to offer compensation. So we had that for sale by owner sign an agreement with us as buyer's agents to say they're agreeing to pay us a commission. Well, that's an expanded use now. That's a historical use, but it could be used in typical transactions with listing brokers and buyer's brokers to establish that relationship for the seller to pay directly the buyer's agent's fees. We'll go into some risks there and some things to worry about in a second. But the second option is the 2406, which is an addendum to the TREC contract. And there's several different provisions there that have, some are informational, some are enforceable. This particular provision with the seller paying directly to the buyer's agent is the only enforceable compensation agreement in the 2406. We'll go through the other ones. D1 and D2A are informational only. And so I'm going to circle back now, and we'll start, now that we teed it up, we'll go back and look at the 2401. Let's start there. If you notice on this chart, it says it must be executed before signing the 1-to-4. And why is that the case? Well, it's not an addendum to the contract. This is an agreement for the seller for a particular client to pay a fee. And it's before the contract's executed. They're saying if with this client that you list in there, that they have an enforceable contract that's later executed, they're agreeing to pay that amount. If you wait it to the time of executing the contract, what if you send the contract over and send this 2401, but the 2401 is never signed, right? We still have an enforceable contract because the contract's standalone. The 2401's not part of it. And so it's really important to remember this needs to be signed up front before you actually execute the contract to avoid that situation of the contract being separately signed and this 2401 never coming back. Again, that's not being clear. That's not establishing that enforceable agreement that our buyer can rely upon. So it's very important to get that signed up front. A couple things in the 2401, again, this is seller directly agreeing to pay the buyer's agent's fees, is you need to set your client out clearly in there. Right? This is an agreement for that seller to pay for a particular client. And so if you have an entity, for example, they're agreeing to pay a certain entity, but they change over to a different buyer at the end of the day, right? We need to make sure that our buyer that's in the 2401 is the same one that's signing the contract. If it was a husband or a wife or a parent or a child, and the 2401 is different from who's ultimately signing the contract, make sure to amend it up front or to get a new one. So the 2401 client matches who's the actual buyer in the contract itself. And remember, if you amend the contract later, once you get to that stage, You have to look at amending the 2401 separately as well. There's a big reason why I think the 2406 is a better option here than using the 2401 for seller direct compensation. And besides making sure the client stays the same, the buyer stays the same, is the agent is actually signing the 2401. This is between the seller and the agent. One big reason you see in our TREC contracts, in the reasoning, if you listen to our broker lawyer committee meetings, that we're leery about putting farm and ranch language in all the other contracts, is that makes the agents have to sign it. And then they can become parties to the contract. And that creates potential liability exposure points that may not have otherwise been there. And so if you're looking at this form, you're almost inserting yourself into the transaction and creating additional liability if you don't amend it properly, if you don't keep up with it. And the 2406 accomplishes largely the same thing. So I think once we go over this 2406 here in a second, that is the option that I would take as a broker, because it keeps it all within the same contract. We don't have two separate contracts, two separate pillars we're trying to establish. Is it an option for 2401? Absolutely. But again, I don't think it's best. And if you look at some of the parties are saying, well, let's just add it as in paragraph 22 as an addendum. Let's put it in there as something that's attached. Well, that's where you're making yourself a party to the contract. But buyer and seller are not both signing that 2401. That's just the seller and the buyer's broker or the buyer's agent, right? And so you're inserting yourself into that transaction as a buyer's agent by having that signed in a way that creates, and there's arguments both sides. Let lawyers talk and get in a room and argue. Some will say, absolutely not, you're not becoming a party to the contract. And others say, well, yes, you are. And so it just creates more risk where it's not necessary with the other form. So let's jump to the 2406. And the 2406 has a provision in there under paragraph D2B. So if you look at the third column here, it's executed with the contract. This 2406 is an addendum. It's the addendum regarding broker's fees. And remember, the 2406 is the only enforceable provision for compensation in that agreement. The other ones that we'll go through in a minute, I don't want to confuse us now, are not enforceable. They're just informational. So this operates largely the same way as a 2401. It's where the seller agrees to compensate directly the buyer's agent. Takes out this MLS broker-to-broker compensation agreement. Takes out any other broker-to-broker compensation agreement. The seller's agreeing to pay directly out of their pocket to the buyer's agent, not out of their pocket to the listing broker, then to the buyer's agent. And this is a lot easier to keep up with, I think. Again, it's executed with the contract. If it needs to be amended later or changed, it's amended as part of the contract itself. Now, in both of these forms, it's very important to, if you look at the 2401 first, you have to keep track of the term as well, right? So this is another thing that it has if you have put a term in there of 1 month, but you don't execute the contract until 2 months later, you're outside that term. This 2406, you don't have to worry about that, right? The 2406, again, is with the contract. If that contract closes, you're getting paid. Whereas you execute that 2401 and then you don't go under contract within the term of that agreement, the time period, basically it begins on X, ends on Y, then you may be missing out on having that enforceable agreement in place. So it also satisfies that concern. And I really think it's a very simple one to use, especially a lot of these brokers that we're not doing any buyer's agent compensation. This is the form that you'll look to. At the end, I'm going to go over what the TREC proposed contractual changes are. And that may wipe out the 2406 in terms of this provision, because we're looking at adding seller concessions or contributions right in the contract itself. And that was approved for publication by TREC on Monday. But we'll go through that. So no, I know, head spinning. This 2406 may be baked into the actual TREC contract soon. Let's go to the last scenario real quick. Again, go back to this chart. If you're in the scenarios, go back and listen to the video on this particular point, or go focus in on that. But let's look at the situation of listing broker only now. That's the 2402 that can establish that. This is the historical MLS offer of compensation. This is establishing a broker-to-broker enforceable agreement. The listing broker agreeing to pay the buyer's broker in the transaction. The 2402 has a lot of the same issues as 2401 in terms of keeping up with it. You have to look at the term. Again, when's it effective? Make sure you bake in enough time of the term that you reasonably can go under contract within it. Or it's tied to your buyer's rep agreement term. Something to make sure that you're not putting just a week when you know it's going to take 2 weeks to negotiate and go under contract. Another issue with the 2402, let me pull up my list here, make sure I'm not jumping ahead, is or I guess a benefit to 2402s. It's a little known, I think, right now, because it hasn't been a big issue, but broker-to-broker agreements do not have to be in writing, right? So remember that if you have an oral conversation with somebody or a text conversation with somebody that has contractual terms saying, hey, me as a listing broker, I'm willing to pay you buyer's agent X, that can be enforceable. And we think normally of, well, the buyer, the agents to the buyer, the agent to the seller, that has to be in writing, right? And we think that bleeds over to all commission agreements, and it doesn't. So remember, these conversations you're having as a listing broker and a buyer's broker about the amount to pay, you can establish an enforceable agreement through those communications. This 2402 on the beneficial side helps establish that firm arrangement, right? It removes the he said, she said argument later down the road. So I think it's really good in that sense to actually establish the agreement. And if you look at the end of it, it has this clause in there that states, this agreement supersedes any discussions we have before this. So not only is it may not be the only, the first one that you have, but if you had any of these other discussions of maybe X% or maybe Y%, this would actually say, that doesn't matter what we discuss. This is establishing the broker-to-broker agreement to pay the fees. Just like the 2401, it's important to get it executed up front. It's not part of the contract. It's not an addendum. It's a whole separate contract between brokers. And make sure up front that this is amended if necessary. If you had X% in there when you first started negotiating, but as part of the deal, you decided to change it to Y, make sure that's amended in the actual 2402. One of the common questions we're getting is, well, why don't I just list that in the 2406, the change terms? Yeah, we may have said X in the 2402, but we're going under contract. And let me list that in the 2406, which again, that's the addendum, 2406. And the 2406 D1, if you have it in front of you, look at D1. That has the listing broker will pay. And a lot of people are saying, well, we'll just use that. Let's use that to amend it. Remember, that's not enforceable. TXR did a good job of putting a parenthetical in there saying, this is for informational purposes only and doesn't change the separate contract that we have. So keep that in mind. If you have a 2402, the deal is changed, amended up front before signing the contract. That way it's established firmly what the broker-to-broker agreement is. So if we jump forward, the next side is really combining a lot of these, right? These are when we start getting into the options that are just spin-offs of the others, when we're having the buyer and seller pay something, or the buyer in the listing broker, or the seller in listing broker. All these different options are really just spin-offs of the original four things we went over. And so if we look at the situation of the buyer and the seller, option one, right? We always have to have the buyer's rep. That's where the buyer's agreeing to pay. But then if the seller's agreeing to pay, we can use the 2401. Or in the second column there, the second option, of course, buyer's rep, and we can use the 2406, which again, I think is the better option here. If we look at another one of the buyer and the listing broker, again, that's base buyer's rep. It's went over the 2402, the broker to broker agreement. to pay those fees. Or the seller and the listing broker, combining it here, it's there's the ability of both the seller and the listing broker to pay some amount. And that's the 2401 and the 2402. And so we have to keep track of these things, though. We have to keep track of who's paying what. And I want to focus now on a little bit on that column. I think of the first three, if you look at it, maybe not right now because there's so much being thrown at you. But if you look at those combinations of the first four columns, those make pretty easy sense. That seller and listing broker, when we have a combination there, and we're using a 2401 and 2402, those are separate individual contracts, right? We need to make sure the total that they're agreeing to pay on the, if we're looking at this from the buyer side, totals up to what I'm expecting to get as a credit. Or that the, if we're establishing this as a buyer's broker, make sure those total up. On the listing broker side, you need to make sure your agreement's clear on who's paying what in terms of you as a listing broker and you as your client, as the actual seller. There's a great video that David Jones and Robin Harris put out yesterday on the new listing agreement and the new language in there. And it was a great change that helps with that discussion with our client as a listing broker and between our listing broker and the seller to say, here's how that listing agreement works as between the two of us. And whatever's established in there, you need to make sure it lines up with anything you've executed in the 2401 or 2402 in terms of the 2401, the seller paying, or 2402, the listing broker paying. And so circle back to your listing agreement in that box to make sure that's established and understood. And if not, before you execute any contract, this isn't that pinkish peaches field here, make sure that's established and changed before you sign the contract. Same with the seller and the listing broker under the second column, right? So this is just the spinoff. We're removing the 2401 and just using the 2406 instead. Because those are interchangeable, but once executed with the contract, and again, I think best using 2406. But we still need to, on the listing side, make sure our agreement with that seller matches up. As I'm talking about this, as much as I've been over this, I'm confusing myself as I'm talking about it. That's why it's really important to have a chart like this, right? It's important
I
to
have
go back.
a real-time question if you're open.
Sure.
Are we opening it up to questions? So I literally am, I'm on Bridget Ramey's team and we are submitting our first offer with this new world. And so basically on 2406, the listing agent confirmed that there was no agreement in his listing for what I was going to be paid. So then we're already in section D2 of 2406.
Okay.
And so I checked, and I've heard a couple different things. I checked D2, 3%, and then I also added 2401. So I have 2406 and 2401 in this contract that we have submitted. Kelly has let me know that that might be redundant, but I had heard from another person at the brokerage that that was a-okay. So would love to just better understand that, one, so I can potentially get an updated offer over, and two, just wanting to truly understand the difference. Kelly let me know that A is for sale by owner, and then that B would be, they do have another broker. So I have like the information about brokerage services. I like all the paperwork that I could collect, I did. So I have 2406 and 2401 and our information about brokerage services in the contract that's been sent to this agent.
And so to tee this back up with the with the names, remember this is a public forum with everybody that's here today. And the question is, when you have the 2406 D2, which is between the seller and to pay the buyer's agent, but you also have the 2401, which essentially does the same thing. Remember to look at the parenthetical in D2 to help explain this. It says, do not use this section if there's a separate written agreement, meaning, and it has the such as the 2401. And the reason for that is you can have conflicting binding contracts. Right. So if you have 2401 that's already signed, right, that's pre-contract stage. Where you haven't executed a contract yet. And if that says X%, and it's real important these things. Let's use X and Y for percentages and commissions instead of actual numbers. But if it says X% in 2401, that's already executed before the contract. There should be. And then if you have a whole nother separate contract using the 2406, that's different. Which one controls, or is it doubling up? You have two contracts for that seller to pay. And that's why they use that parenthetical there. Do not use the 2406 D2 if you already have that 2401 signed. And so in that case, I would just use the 2401 or terminate the 2401 and put it in the 2406. So you don't have two separate pillars of enforceable contracts up front. And it avoids this legal argument that lawyers can make of that's double the fee now that we get, from the seller. And it avoids whether that actually wins the day or not, to say, no, it wasn't a meeting of the minds. It really was the same thing. And it should go this way. Lawyers are going to argue about that. That's going to be decided probably at some point in the courts after a lot of attorney's fees and a lot of money is spent. And this is where it's frustrating as lawyers that there's not that many good, I say not many good, there's a lot of good lawyers out there, but not a lot that understand, and reasonably so, the minutiae of these contracts. And you're going to have a lot of people saying a lot of different things on how these contracts work, and I think litigation is going to come out of it. But the one thing that you can be clear on is if you have a 2401 signed, do not go forward with the 2406 by its own terms until that's either done away with, terminate the 2401 and just use 2406, or stick with just the 2401. That's the intent of this, not to have both.
Question for you. I'm running into this is my third offer we've written this week. And a lot of sellers and sellers agents are refusing to give any information before an offer is submitted. So in that case, we would not have 2401. We would only submit 2406 with our offers.
Exactly. I think that's the best practice here, to make sure you have something established. And the 2406, in my view, is a lot cleaner way to do it. It's part of the contract. You're not, looking up front to establish anything. Now, there could be situations that 2401 is advisable. If you have a particular party that you want to get locked in at a point that, before the contract stage, thinking if you start negotiating the contract 2 weeks from now, they may be in a different mindset and not willing to offer that amount. That's where 2401 could be beneficial and used to lock them in. But they refuse, or in the most standard cases, I think that the 2406 is the reasonable one to do with the contract, because that's what your client's willing to do. And that's looking at it from the buyer's perspective. As a seller, I'd want to try to keep flexibility, right? Looking at it from both sides. I wouldn't want to get myself locked in to pay a commission until I get to the contract stage. And that's the 2406. And so you say there's a question there I see from Jennifer in the chat real quick, and why can't you submit the 2406 pre-offer? Well, the 2406 is an addendum to the contract. It's not a standalone agreement. So it's meant to be attached as an addendum to the actual contract itself. And so I think those are helpful things. And this is where we can start talking out the actual situational issues that arise. So I'm not sure.
We have a couple of situations, John.
Sure. Jump right in.
So in the case, we have the listing agent actually letting us know that go ahead, send us over the 2402. We are offering that compensation. But the listing agent fails to do that. Our buyer wants to submit that offer. What's the best advice to do in that situation?
So in that case, this is when you do not have the 2402 signed up front, and the listing broker saying, just trust me, we'll pay this. This is what we're thinking, or this is what we're offering. Well, remember, that's potentially enforceable. So be careful as a listing agent if you're making those statements, because oral agreements between brokers can be enforceable. To get past that, on the buy side, for everybody's sake, needs to be clarified. It needs to be established in an enforceable agreement. And so then you would use the 2406. Right, the 2406 will establish an enforceable agreement for payment of that commission. And that will be between the listing broker and the seller. The seller's gonna be like, wait a minute, I said authorized you to pay that amount to the other side. Why are they making me pay it in here? Right. And then that's where the clarity comes in. And that's where they can have that conversation. In the new listing agreement language that just came out effective tomorrow, makes that clear that the listing broker is not keeping everything in that scenario, right? So before we used to say X% in the listing. Let me step back for a minute. In the old listing agreement, we used to say X%, and we would offer some of it to the other side via the MLS. But if we didn't pay anything, generally we were able to keep the full X%. The new structure of the listing agreement says, okay, it's X%, and I'm going to offer this much to a cooperating broker. But if I don't have to pay that cooperating broker, you're still not paying the full X. Now you get the difference between the two as if I paid the listing broker.
Mm-hmm.
So circle back to the situation we have now on the table of they're refusing to sign the 2402 up front. Well, functionally using that 2406 is going to be the same thing under the TXR forms, and establishes an absolute enforceable one instead of having a he said, she said over what you told me you would pay me beforehand.
Mm-hmm. Another situation for the 2401 here, if Lucy were dealing with that form, we approach an unrepresented seller, we get that 2401 signed, and then submit an offer. Is it your guidance that we maybe cancel that and switch to 2406, or just keep that 2401 in place?
So it's a little situational there, but the 2401 with an unrepresented party, if you're looking at early stage in the process and you want to lock something in, I think that's where the more benefit of establishing that up front, right? Then you're inserting yourself a little bit on the buy side to the transaction at that point. You have to make sure the term is, follow the term of the agreement, make sure the time period's right, make sure the client's right. We have these extra hurdles, but I think the benefit of that is locking them in. You can also wait to the 2406 stage the time you sign the contract. And if you're moving quick or just in a general scenario, you're not worried about them backing out of making that agreement to pay the fees, then that's a good time to do it. In either case, it needs to be clear. But remember, let me go back to the chart. You need to make sure the 2401 and 2402 are signed up front, are signed before you execute the contract. So don't let the numbers and the confusion over the actual provisions get away from this roadmap. Follow the roadmap first. You can't make two turns for now before you make the first one. So follow this chart. If you're looking at one particular option, make sure you take the right turn first before you make the left one. And in that case, I've been seeing the perfect world. Kirsten, as the 2401 are presented and signed before you submit an offer, the broker are laying their cards on the table up front, right? So this is where it's establishing it and making sure they don't back out. And if that's a big deal point for your buyers now that they're having to pay these fees, right? This gives them some certainty of, I want to invest more time on this particular negotiation. I know they're going to pay part of the fees that I need help with. And you're worth it, buyer's agent, and I've already agreed to pay you, but this will change my decision-making up in the contract, and I'll focus more time there. That's another situation where it might be good. And so there's lots of different scenarios where it fit in, but just make sure first follow the roadmap and follow the rules. Let's see, so somebody asked, can we access the video after the call? Absolutely. All these, I really want this to be a weekly webinar that you get your questions asked. We'll post it on Facebook, post it on YouTube, so you can go back and listen to it. And again, I've lived in these forums a whole lot every day, almost all day, and they still make my head spin. And you ground yourself somehow. This chart's how I ground myself every time. And the numbers are now starting to make sense to me, but I know that's not the easiest thing. So there's Kim Burke asks, what form do you use to terminate the 2402 and 2401? Well, there's not a published form for that purpose. So this is one where it would be an individually developed form to actually terminate it. And termination agreements can be simple. They don't have to be very complex, but make sure it's signed. Any termination form that's signed has the signature of both parties to it. So the 2401, make sure it's signed by both the seller and the buyer's agent. Or the 2402, make sure it's signed by both brokers. That's the one big thing in any termination. You want to make sure that it's clear, and anybody that signed the underlying agreement signs the termination. And the chart, will you please email the chart? Yes, we can email that out if to everyone. It's also available on our Facebook page. If you go to Special Provisions Facebook page, that's where we post the videos and the chart and a lot of other files. But if you ever need anything, feel free to email me or message us on Facebook. Jennifer says, I have a listing in which the seller is a lawyer. He only wants to offer a concession based upon the buyer's agent's offer. And I think that's reasonable, right? So this is, the buyer's agent's offer. So is that the actual contract where it's really the buyer's, I guess the buyer's offer, to make sure they're not something.
Yeah, I'm sorry. Yeah, the
separate.
buyer's offer. Yeah, he only wants to be able to negotiate a concession based on that.
And that's a great way to look at it from the seller's perspective, right? If you're a seller and you're selling it, every deal is going to be dependent on the entire picture. I'm worried about my bottom line. And that's where the 2406 fits right in, right? Because you're negotiating
being that
that
that's an amendment, how does that work? If because you can't send that ahead of time, the 2406, because it's an amendment to a contract.
Well, in a little, it's an addendum, meaning it's a part of the contract.
Addendum,
itself.
I'm sorry, yes, an addendum to a contract that's already established, right?
Well, no. So the at that stage, if we go back to this chart on the screen, in the blue, we're not executing the 2406 unless it's attached to the contract. It's with the contract that's sent over. So it's part of the offer.
So that's where you just be quiet, you don't say anything, and you just say submit the offer, right?
Correct. Exactly, which is one way. And if we look at this for like the third-party financing addendum, let's bring it back to something we all are very comfortable with. If we check that third-party financing box and send it over with the contract, if it comes back signed, the contract, but not the third-party financing addendum, we don't have a complete contract, right? Because that third-party financing addendum was part of it. It was an addenda to the contract.
Okay, yeah, you're right.
Or addendum to the contract. And so in this case, the 2406 operates in that sense in the same way as the third-party financing addendum. If it's put as part of you would check box in paragraph 22, other, right? Write in 2406, that makes it an addenda or addendum to the contract. And then if it comes back and that's not signed, we don't have a contract yet because we don't have all the forms signed that need to be signed. Just like if you didn't have the third-party financing addendum signed as well.
Hey, John, it's Kim Burke. I'm going to ask a really dumb question. On your chart, when you say seller one option, seller only option two, and listing broker only, can you just dumb it down for me? What do you mean by listing broker only? What does that mean?
So that's where the listing broker, let's say the commission is X, right? Whatever on the buy side commission is X. That's the listing broker paying all of X. Right, they're agreeing to pay the full percentage or full flat fee, the full amount. Where the seller only options there, who's paying buyer's agent commission at that point, right? So the seller only option, if the commission's X for buy side, the seller is paying all of X. Or in the first column, we're going backwards here, going in reverse. If it's the buyer, if the commission is X, buyer agent commission's X, and the buyer is paying the full amount of X with nobody else.
Okay, so seller only option one and two, or if there's like a combination of buyer agent pushing in and then seller paying for a little bit. Is that what you mean by that?
I'm back on. Can you hear me now again?
Yes, we can hear you, John.
Okay, perfect. Sorry about that. Had a little audio issue. So, Kim, I believe.
Can you bring that chart back up, John, real quick?
I'm doing right now. Let's see. Here we go.
There we go. Yeah, and the question is, we're on seller only option one.
Okay.
Using the 2401 to establish the enforceable agreement with the seller.
Mm-hmm. So this is where, starting at the top of them paying the seller paying everything. Remember, in every case, and where this might get confusing is having that buyer's rep column in there, or buyer's rep row. But remember, we can't collect anything, even if the seller's paying it all, saying, I'm willing to pay everything. We can't collect unless we have a buyer's rep in place. So that's why the buyer's rep is in all of these. And if we look at the difference between seller only option one and only two, is in which enforceable agreement are we making the seller pay everything? The 2401 being outside of the contract, a wholly separate agreement that establishes the amount they're paying. And then if we look at the 2406, it's in the contract itself. It's part of the contract where the seller is agreeing to pay it as what we consider concessions, right? So if you look at concessions for other expenses, that appraisal fees or survey, whatever these other expenses that the buyer may have paid, now consider the 2406 the same thing, that it's a concession in the contract that the seller is willing to pay. And it establishes an amount that's paid specifically for the buyer agent compensation purpose.
And then, John, just to add a specific scenario, so would it be correct to say if seller only option one, that might be a situation where you're dealing with an unrepresented seller, whereas seller only option two, both parties are probably represented on both sides, a listing agent and a buyer agent. Would that be correct?
Yeah, I think you can have represented under both. Historically, option one was FSBOs, right? The for sale by owners, where you didn't have representation there. That I think was the vast majority of situations that that form was actually used. Now it's has an expanded use. It has a much more expanded use. It's being used out there, and it can be used there. It hasn't been limited to when they're represented. But that expanded use has brought over all these other concerns we're talking about that make it where you have to keep up with it. It introduces potential places for error or not keeping up with what needs to be amended and how to amend it, right? With no termination form, you know, to terminate it, to do something different. You really have to keep track of a lot of things. And so that's where you go to the 2406 as part of the contract being, I think in most cases, the better option to go with. And it keeps it cleaner. It functionally operates the same way, but it just makes it easier, I think, for both sides to keep track of one document instead of two separate contracts.
So John, Kim Burke again. So essentially, I feel like this is all, first of all, we love you. You're amazing. Thank you so much for all these forms and being a part of the group to fix these forms. But I feel like we should just go status quo. Like everything should be 2406, because it's not like we call a listing agent and say, hey, are you going to pay title policy? There's an assumption in a lot of this. Like, look at all terms of the contract. And to start throwing out 2401 and 2402s before you even set in the property, I feel like that kind of creates some contention and stress. It's like, why don't we just go in, best foot forward of what our buyers want to present and do 2406?
And I fully agree with that. I fully agree that that's the smoother, better route. This chart right here is meant to show you all of the options that are currently available, right? So that's what we're going through today as you are presented with 2401s. You look at 2401s. This is giving you all the options.
Okay, but I add one thing, John, to that.
Sure.
He asked, why are we not going to 24/6? Because I hear you and I am in alignment with that. But why we are not all jumping to that is because I think so many of us are trying to hold on to the traditional method of securing our compensation up front. And we had that agreement. We had that one lane highway with the MLS, and now we do not. And so I had my hand raised. I wanted to have you elaborate, John, on the fact that while we have 2401 and 2402 up front that we can get signed, can you talk about the fact that that is still negotiable with the offer?
Mm-hmm. Yep. So even though you have those two, like as Kirsten said, you may have those signed, but everything remains negotiable. You haven't signed that final contract yet. You haven't bound the parties for a buy-sell under this sales price and these other terms. What you have done is locked the parties in within the term of those 2401 and 2402 for payment of certain fees. But you can still negotiate that all the way through the time that you sign the contract. And even afterwards, just like you can still negotiate a contract and amend the contract and negotiate repairs and such. You can still negotiate all this compensation issue, and you're just bound more with maybe not outside your option. You have less weight to actually try to get an amendment. But just because you sign a 2401, 2402 does not mean it can't change. And you just need to make sure before you sign a contract, if that's part of the deal, you do amend it, you do change it at the end of the day, because you don't want to have that hanging out there as an enforceable agreement that doesn't match up to the actual deal terms. And I want to jump forward real quick that may totally change the practice coming up. And this is something that may eliminate the use of 2401 and definitely 2406. But on Monday at the TREC meeting, we had as the broker lawyer committee, I'm the co-chair of the broker lawyer committee. I speak today on behalf of myself, not on their behalf or TREC's behalf, but I presented the proposed changes to the contract, and there are many. So beyond this paragraph I'm showing you on the screen right now, we suggested a whole lot of changes that we've been holding on to for a while because of this compensation issue we knew was coming down the line. What we decided to do with the compensation issue is to recommend adding to paragraph 12A a subsection that operates just like the 2401 and 2406 D2B to allow a seller to make a concession or contribution as it's used in the contract towards a buyer's agent's fees. And so if you look at 12A1B, that subsection B there, that's really the new language that we've suggested be added. And it states the following amount to be applied to brokerage fees that buyer has agreed to pay. So this is an expense that seller's agreeing to pay in the contract itself. If this ends up going through, you'll see it in the public comment, for public comment, as TREC approved it to be pushed out for comment. If this happens to go through, then 2406 should go out the window, and in terms of D2B, right? This agreement that we're looking at here, right, in 2406 at the bottom line that you execute with it, it'd be redundant of what is in the contract itself. And this is I think a lot easier concept for us to grasp as agents, that we've always had seller paying potentially some of the buyer's expenses. And the question has come up, well, why can't we just use that before? Well, if you notice right above my head here right there, it had on the end of that line, a definition of what buyer's expenses are, this right here. And it has this big long paragraph that did not include buyer agent compensation. It includes pretty much every other expense you can think of, but it didn't include directly buyer's agent compensation. And so we added, instead of adding and just lumping it together into definition, we added a separate subsection, which you'll see right here. All right, so this new subsection allows the seller to say, I want to contribute, I'm willing to contribute X amount towards that commission. But we kept it separate, and the seller may not want to contribute to buyer agent compensation. They may still be fine with contributing to loan fees and survey and appraisals and all this, right? So it allows you flexibility in negotiating, but it also provides an opportunity to write in the contract itself. The earliest these can go through, please send in your comments. We need your comments. We want to hear what you think about this. But the earliest this will come out is November. And that's a factor of how government works, how we have to go through as TREC has to go through a process of publication and a process of having the comment come back and effectively 2 votes at meetings to push through contractual changes. We think this was a great first step to help solve this issue, to avoid having to worry about the 2406 D2B. Hopefully, the practice 2401 will still be there unless Texas Realtor changes it. But this will allow us right in the contract without having to worry about another form, establish that agreement. I didn't lead off with it up front because the chart itself is focused on the current forms that are for use. But this box down here that you can see on the 2406, that may be replaced with the actual contract itself.
Two questions in the chat for you. One is, why would you use a 2401 if you already have a listing agreement with the seller?
So this is if you're on the buy side, you're not part of that contract between the listing agreement with the seller and the listing broker. On the 2401 side, you want to lock that seller into paying a commission that the buyer gets the benefit of. All right, if you already have that listing agreement, that benefits the listing broker and the seller. This is trying to benefit the buyer to make sure they understand how much the seller is willing to pay.
All right. It looks like Kirsten actually answered the second question in the chat, so we're good there.
My question is, our standard practice is we generally get paid, sorry, this is Tammy Bennett. We get paid by the listing broker. To me, that seems like Kim was saying, go status quo, is put on your forms and have the agreement with the listing broker, and then put on your 2402 that the listing broker is paying your fees. And that should be confirm what the listing broker and the seller have agreed to for commissions in their listing agreement.
And historically, by numbers, it was a broker to broker payment, right? Through the MLS, whether everybody realized it or not, the MLS created a binding contract. In the MLS terms that you agreed to when you signed up, it has the contractual language in there. And so we didn't need anything more. Now that's out the window, the 2402 jumps in to satisfy that contract, to satisfy that broker to broker agreement. And so to the extent that brokers are still offering and we're accepting on the buy side, that 2402 establishes it and makes it clear. So you do have, though, very large brokers out there that are saying we're not doing it at all, right? We're not doing any buyer agent compensation. And I will have a footnote there, even though they say that, everything's still negotiable. Some may have firmer lines than others, right? But it remains negotiable. To an extent a broker to broker agreement is made, the 2402 establishes it. And it would operate effectively like the old MLS agreement did.
But don't you think that would be the best way going forward, rather than, putting in front of the seller's paying for it one way or another? It just seems to me that going through the listing broker the standard way keeps it cleaner.
I would say that's it depends with how the actual practice happens. There's so much confusion right now. There's so many different use of these forms. There's so many brokers that say, I don't want the liability of having to keep track of a 2402 contract. I don't want to have to worry about amending it or having it conflicting with what's out there. I don't think there's going to be a universal mass adoption of use of 2402. I think the current has already moved past to where the seller contributions are becoming more and more common. Would it make it easy? I think in a lot of cases, if we could have a universal adoption of 2402, the understanding would be there and it would make it easy. I just think practically that's probably not in the cards as much as on days I would like it to be, to simplify things. And especially if we now see Texas Realtors revising their agreements, right? The new listing agreement, watch that David Jones and Robin Harris video on the impact of these changes that come out tomorrow or must use tomorrow. I think that changing language in there that talks about the relation between the listing broker and the seller in whatever they offer on the other side already being a discount, the seller is doing the same thing and doing a concession as they would in the 2402 or the old agreement under MLS. So you're having the whole industry starting to bleed over to where these concepts aren't as stark as they used to be. And I'd be surprised if the wave ever goes back to being solid, just broker to broker. See, did NAR agree? See, we as a broker only allow 2406. There's lots that are doing that. NAR has 1.5 million members. Did NAR agree to this? I would say this, NAR, and we're right at noon, so we're going to wrap it up here shortly. All of this stuff, and Kirsten has a great point there, of all this needs to be discussion with the broker. And brokers, you really need to get on top of this as well, because the standard ICA agreements, the independent contractor agreements that many use, allow agents broad flexibility to execute commission agreements on behalf of the broker. And so make sure you get out ahead of this to what do you feel comfortable with as a business decision as a broker. Make sure you train your agents on what you expect them to do in the confines that if you only want to use a 2406, that you make that clear. And overriding it all, these conversations need to be had with our clients. Right? Get the roadmap out, understand they are not going to know the playing field. They're not going to even know as much as we do, right? Going into that conversation, but how confused we are. We had to figure out a way to simplify that conversation, to have it of here's the impact. and explain it to them. So brokers, make sure you fully understand what your policies are. Make sure you have those conversations to make sure it's client driven at the end of the day and that they understand their options. Texas Realtors is in NAR are getting it from all sides. And in a lot of these form changes, and this is why we're moving, trying to take it methodically at the TREC Broker Lawyer Committee, is they're pushing stuff out to try to tackle concerns and issues in the lawsuit that are necessarily difficult and confusing. And they're seeing things that aren't working and are pivoting. That's making the soup a lot harder to make or a lot more confusing at the end of the day, but they're trying to keep up with it. We at TREC, just because of on the Broker Lawyer Committee, we can't move fast by the laws, and we're taking measured approaches. And if you want to see the minutia of all these concerns, watch the 11 hours of meetings that we had. They're all publicized on TREC, and they're actually a lot more entertaining than most. It's not just commas and periods. We get into the concerns about each one of these particular issues and uses of forms in great detail. So it can continue to learn on these. This establishes it. I think next week's Agent Legal Lounge will tee up to more of these questions. We'll have the chart available to reference back to. We'll have the forms available, but come back with these questions. Come back with what you're seeing out there, and let's walk through it, right? It's going to take hearing this 10 times over to get it. And what works for one person's brain may be this chart, or maybe something wholly different. But the important thing is we're gaining a firm understanding of everything. And I love this vehicle to be able to do it. Ed, thank you for co-hosting today. Kirsten, thank you again for jumping in and co-hosting last week. We have a lot of conversations between us, outside of this almost on a daily basis. And it really is a changing situation. So make sure to stay on top of it. I'll say, I think we may start a minute late, so I'll go maybe for one of the last two questions, and then we'll wrap this up. And again, this recording will be available on Facebook, our YouTube channel, and we'll hit it again next week. So come with your questions, send them in advance so we can try to address them. And Ed, do you see maybe one last question or two that we can dive into?
Yeah, I did see one up at the top of the chat. There was a question about why Farm and Ranch didn't elect or wasn't covered under the showing parameters. So, can you elaborate just a little bit why Farm and Ranch doesn't need a buyer's representation agreement?
Yep, and I think this is a great way to kind of wrap it up, actually, because it'll take up that time. Is the Farm and Ranch is the only TREC contract, the only Texas Real Estate Commission contract that has an enforceable agreement in it, broker to broker. It has a ratification of fee. And it also already has a separate section that allows the buyer or seller to pay the commission to the other sides already built in. And so this Form 2406 is duplicative of what's already in those contracts. Now, why is that in there? Why is the Farm and Ranch unique? The Farm and Ranch, for several different reasons, one of which is a lot of them were never listed on MLSs, right? A lot of these Farm and Ranch properties were never put in there. So historically, the Farm and Ranch guys needed a vehicle to confirm what their agreement was, to make that enforceable agreement, to establish it up front. And they also operated sometimes that more like commercial deals instead of residential, right? And in the commercial contracts, you had the buyer seller already paying the other side's fees, right? In commercial context, a lot of times they're just concerned about their bottom line. What am I having to bring to the table, or what am I getting out of it? So those concepts have been in there for decades in the Farm and Ranch. Now, we looked at adding that to the 1-to-4 in the last meeting. That was probably the biggest request. I don't have my materials in front of me, but we had hundreds and hundreds of comments come in, and we requested your feedback as the Broker Lawyer Committee on what you wanted to see. And a large part of that was let's see the Farm and Ranch style language in everything. It raises a lot of different concerns there, and one of which is making the agents parties to the contract that we talked about earlier. Right? That really hasn't presented itself in the Farm and Ranch context too much, but you're dealing with a different set of agents, different group. And by introducing that controversy, we were concerned about that. Now, I like the Farm and Ranch language, and this is speaking for myself individually. I think that is one area that we're not saying we won't do, but it's something that we at least the first step was just paragraph 12. And we're going to continue that conversation whether to add it. there's multiple other reasons too. And one that ties into, why don't you just put everything, who pays what? Like the farm ranch style, but then say the listing broker's paying this and to this between the seller and between the buyer. The thing with over disclosure, the concerns that are raised, say over disclosure, you never have too much clarity, except that then you're disclosing your business deal. All the listing brokers would be forced, if we put that language in there, to say, I'm getting this much from my client. And if you put that in an offer, it doesn't go through, well, then they know what the deal economics are on the seller side for the next one. They're going to know your private business deal. How much did you agree? You agreed to pay X with your seller, or your sellers agreed to pay X. Well, then your competition is going to use that to say, hey, when your listing agreement ends, come to me, I'll pay less. So there's a lot of these different concerns that may sound good on its face, but once you get behind it, there's a lot of things raised by it. And ultimately that may be the answer, but we don't want to rush into it because of that. And it's amazing how you get into these meetings and people change their mind multiple different times. I will, at least right now, my mind's changed multiple times too. I'm in the camp of wanting to continue to look at the farm and ranch language in all the other contracts. It doesn't force you to say, this is my commission. As a listing broker, I'm collecting from my seller, but it does provide a vehicle that's just like the 2406 or the 2402 to establish it in the contract. So we'll continue to look at that. I appreciate everybody's time today. I want to respect everybody's time that hopped on. We'll publish this video shortly. And Ed, thank you again for all your help today. And we'll
Thank you, John. Thanks for having me.
We'll pick it up next week. Take care.